Hello, I'm Jonathan Reed at Reed and Mansfield. I want to talk today about the probate process. Now, ideally, if estate planning is done correctly, in the vast majority of cases, it would be desired to avoid probate. But many times, probate is unavoidable because a person dies with only a will, and the will is an instrument that requires probate. The reason it's desirable to avoid probate in almost all cases is because probate is an expensive process. In Nevada, there are a few different ways that attorneys charge for probate. One way they can charge for probate is an hourly rate. And under Nevada law, attorneys are allowed to charge the same rate for the paralegals and secretaries as they charge for themselves when they bill on an hourly rate. In my experience, clients dislike an hourly rate because they have no way of knowing how many hours an attorney is going to bill. And while there are many honest attorneys, a lot of attorneys who are good at the process feel they shouldn't be penalized for being an expert, so they pad their hourly billing. Another way that attorneys charge for probate is Nevada has a statute that sets out probate fees that the court will automatically approve if the client has agreed to these fees. These probate fees for estates not greater than $1 million are $4,000 for the first $100,000 of assets, $3,000 for the second $100,000 of assets, and then 2% for the next $800,000 of assets. Now, the attorneys wrote the statute, so if, for example, the probate estate contains a house that is worth $500,000 and it has a $300,000 mortgage, there's really only $200,000 there when you subtract the mortgage. But the way the attorney's fee statute is set up, the attorney is allowed to charge the full value of the house, in this case $500,000, without deduction for the mortgage. Now, there is another statutory scheme, which is the amounts that the personal representative of the estate can charge. The personal representative is either the executor, which is a person named in the will to administer the estate, or an administrator if the person dies without a will or if none of the executors named in the will are willing to serve. The statutory fee for the personal representative is $3,150 on the first $100,000, and then it's 2% after that. In addition, the personal representative's fee is reduced by the amount of a mortgage on real estate. So in the example we just talked about, if the estate consisted of a $500,000 house with a $300,000 mortgage, the personal representative would charge a fee based on that estate being worth $200,000, not $500,000. At Reed and Mansfield, we offer to do probates for the statutory personal representative's fee, assuming that everything is uncontested. So that gives you a savings both in terms of the absolute rate and in a really big savings when the mortgage is involved, because the mortgage amounts are deducted from the value of the estate for fee calculations. Surprisingly, there are actually some attorneys in Nevada who get clients to sign a contract that says they will get paid the greater of the hourly fee or the statutory attorney's fee.